Hello there, my name's Ben Fogarty. I've been invited by Judith Hudson and the Dear Dyslexic Foundation to present. So today my topic is living successfully with dyslexia in Australia, surviving and thriving in a non-dyslexic world, the topic being disability in Australian law and policy. I prepared some PowerPoint slides. Today I'll be going old school with paper, so forgive me if I'm looking down and turning paper. It may though assist when you have my notes with you to know which page and which slide I'm up to as we go. Firstly, the topics that I'd like to traverse today. Hopefully I'm not too ambitious in the time allocated to me. After an introduction, I'd like to explain what the disability discrimination laws are in Australia, with real focus on the Australian law or the federal law, the Disability Discrimination Act. Then I'd like to discuss what's unlawful under that Act, as the courts and the law understands discrimination in Australia, because a layperson's understanding of what discrimination is or might be can be very different to what the acts and the legislation and the courts interpret and define as discrimination. I'd also like to talk about the education standards which append or augment the Disability Discrimination Act. These are standards that came into being in 2005. They tend to drill down into more detail around what education providers need to do or ought to do under the Disability Discrimination Act in education. After that, I'd like to talk about what exemptions or defences there are under the legislation, in particular the Disability Discrimination Act. Then I'd like to discuss the topic of what can the law achieve and what can't it achieve. I think that topic is a very important one for people who might be on the precipice of contemplating taking a discrimination claim to court in Australia. It's really important to understand what the law can achieve and really, probably more importantly, what it can't. The seventh topic in my list is the Fair Work Act. I note I've been asked to, and the audience are interested in hearing topics to do with education and employment. The Fair Work Act obviously relates to employment, not education. It's an important tool in a discrimination lawyer's armoury, so to speak, when a complaint comes to them of unlawful discrimination in employment. There is another avenue or avenues to take under the Fair Work Act where there might be discrimination in employment, not just taking a matter through the Disability Discrimination Act or with the Disability Discrimination Act. So I'd like to highlight that. The last two topics, 8 and 9, are more practical, some practical tips. One is, number 8 is making a complaint and warding one off, practical tips. And then the 9th and last topic is judgments and possible scenarios. So there I've included some references to important cases that have been decided regarding the Disability Discrimination Act. Some the applicant has won, some the applicant hasn't won. Obviously one can learn as much from a case where an applicant, a person with disability, hasn't won or hasn't prevailed in their claim as for one where an applicant has. And then I've set up some possible scenarios for you to think about. Perhaps if I get time, I might discuss a couple of those. But they are scenarios that aren't unlike scenarios that I have come across in my now 20 odd years of being a lawyer and 10 years this month as a barrister. Turning first to topic 1, introduction, just so you understand my background. As I've just said, I've been a barrister for 10 years. I do a real range of work. Presently, I'm a junior barrister in the Disability Royal Commission in Australia, which is an inquiry into, or a commission into, violence, abuse, neglect and exploitation of persons with disability. Very far-ranging compass to cover, but it's a very interesting one to be working with the Commission and assisting it in its task. I also do employment law, I do criminal law, I do guardianship and financial management law, I do tenancy law, I do a real range of work for legal aid clients, so assisting them to bring claims against government agencies quite regularly, and also legal aid clients where they're caught up in the criminal justice system or the criminal courts. I've been a lawyer for about 22 years from memory. Prior to becoming a barrister, I worked in the community legal sector in Australia, mainly in Sydney, but also in Darwin in the Northern Territory. And my work there, again, comprised a real range of work, including discrimination work. So I've essentially taken that work there and continue to do that at the bar. One of two places I worked at were disability specific. One was and is the Intellectual Disability Rights Service in Sydney, New South Wales, and the other is what was formerly called the Disability Discrimination Legal Centre, now the Australian Centre for Disability Law. I worked at both those places prior to becoming a barrister, and really there my enjoyment, my passion for doing discrimination burgeoned. What I talk about today, to be clear, is practical suggestions, advice, recommendations. It's not legal advice. You'll hear lots of lawyers tell you that, hopefully tell you that. So please, if you have specific queries or questions or scenarios, you're best placed to speak with a lawyer to get specific advice about those. But I'm hoping that what I provide today, the practical guidance and some references to resources, will really help you to understand the complexities of disability discrimination law and policy, and to navigate those, or to go to the next step of where you can find more support and assistance. My focus is going to be the law as opposed to policy. Obviously one is, in my view, is as important as the other. My focus though as a barrister for 10 years has been the law. I did some policy work in the community legal sector prior to that, but really my focus today is the law. As I've already said too, my focus today are the areas of employment and education. You might know, and it may be of some assistance to some of you, that the Disability Discrimination Act and related state and territory acts cover other areas, such as accommodation, such as Commonwealth laws and programs, such as provision of goods and services, but I'm not going to deal with those areas today. I'm focusing on employment and education. The act that is the focus, as I've said for my talk, is the Disability Discrimination Act. You might hear me lapse into the vernacular of DDA. That's shorthand for that act. The last thing in terms of my introduction, and I think I've said this to you, is my focus is about what is achievable with disability discrimination law, what can be gained by taking as it's called, a complaint or a claim to a court or tribunal, and importantly, what can't be achieved under the law, and perhaps is fodder for policy and media intervention, topics I won't cover today. So the first topic of what are the disability discrimination laws in Australia, I've mentioned to you, of course, the DDA, and I've mentioned to you as well the education standards, formally, the formal title being Disability Standards for Education 2005, and I've referred to those in the PowerPoint. As well, across the jurisdictions of Australia, there exist state and territory discrimination laws that complement and overlap the DDA and other federal discrimination laws. Those state and territory acts cover not just disability but other attributes, including, for example, race and sex. It's worth knowing that they exist, very much so, and in New South Wales the relevant act is entitled the Anti-Discrimination Act 1977, And there are comparable state and territory anti-discrimination acts if you reside in a different jurisdiction. The last law on my list on the PowerPoint is, as I've mentioned earlier, the Fair Work Act. And I'll come to the relevant provision there that protects or provides recourse for discrimination in employment, but for reference, it's section 351 of that Act. It's quite a large Act. Moving to topic number 3, what is unlawful under the DDA? And I'm going to talk to you about direct discrimination and indirect discrimination. These concepts, or these forms of protection or forms of contravention, I should say, of the Act, of the DDA, also feature in those state and territory acts. So what I talk about here applies equally with some tweaks to those other acts in the territories and states. The first form of discrimination is direct discrimination, or direct disability discrimination, if we're focusing on disability as the attribute that's being protected. Put simply, direct discrimination is treating a person with disability less favourably because of their disability. An example, and the example I provided in the PowerPoints, is refusing a student with autism permission to go on a school excursion without a parent accompanying them when his peers aren't required to bring a parent or carer or guardian. It seems simplistic and not complex on the face of it, but when one reads the judgments, when one runs a case in court or in a tribunal, one finds real complexity in proving the elements of direct discrimination. The key elements really are, was the act done because of the disability, sometimes called causation? So, was a student refused to go on excursion because of their autism, or was it some other reason? And then the second inquiry, when one looks at direct discrimination, is how are other students without that disability treated in the same circumstances? Or how would one without the disability be treated in the same circumstances? This element is sometimes referred to as the comparator, and both of these elements must be proven by an applicant or complainant, as they're sometimes called, to make out direct discrimination. They're difficult sometimes to prove on the facts. Often the evidence of these things, particularly why someone might have been treated by a school or employer in a particular way, the evidence or proof of that may well sit in documents or with witnesses within the employer or the education provider. Similarly, how a school or how an employer might treat someone else or might have treated someone else without the disability in the same circumstances might often be evidence that is only within the possession or knowledge of the employer or education provider and not the person with disability bringing the complaint. So they're issues from the outset when one is first starting to look at a claim or complaint. The second form of discrimination is known as indirect discrimination or indirect disability discrimination. It too is complex, but as best it can be crystallised, it's imposing a requirement or condition, and that can be inadvertent. It doesn't have to be with knowledge, where the effect of imposing that requirement or condition is that a person with disability cannot comply with that requirement or condition, and it is not reasonable to impose that requirement or condition in all of the circumstances. An example that might be pertinent for today's purposes is refusing a vision impaired student use of a laptop and computer screen reader in class. It might be a rule at a school that says no students are permitted to use their laptop in class. Now that's arguably a requirement that's imposed on all the kids in that classroom, including the vision impaired student. The effect that has on the vision impaired student, one would suggest, is much more adverse than a student who may not be vision impaired. So you have an inadvertent requirement or condition being imposed on all students in a classroom. You have a vision impaired student who, it is argued, cannot comply with that requirement. So that student cannot engage in reading material, looking at the board, recording what they're hearing without their laptop. And then the final question is, was it reasonable in all the circumstances of the case to impose that requirement or condition? Why did the school impose that? Why didn't it consider an exception? Again, the elements of indirect disability discrimination, other than reasonableness, must be proven to a court or tribunal by the person bringing the claim. Reasonableness, whether the requirement or condition imposed was reasonable in all of the circumstances, so that brings in a lot of factors, not just the impact on the student with disability, but perhaps the impact on other students in the class, the teacher, perhaps financial resources. That element has to be proven in the reverse by the school or the employer. Again, indirect discrimination can apply in the education or the employment contexts. Continuing on this topic of what is unlawful under the DDA, another form of direct and indirect discrimination that I call newish but actually came into effect in 2009 is where an education provider, a school, or perhaps an employer fails to make a reasonable adjustment for a student or employee with disability. Now, this protection or this provision doesn't go so far as to say that there's a positive duty on an employer or education provider to always provide adjustments that are requested. It doesn't quite go that far. But it has proven a useful and strong form of discrimination in some cases that feature at the end of my paper that I've referred to, particularly in the employment context, and is one that is now being run in cases which often, I must say, settle before they run to court. In other words, failure to make a reasonable adjustment may amount to direct or indirect discrimination. I've inserted an example, and that is failing to provide an essential university course document in accessible format to a blind student. The student would say, providing that to me in Word format or in a format that I can read that material on my screen reader, for example, is an adjustment that's necessary for my disability, and in the circumstances is a reasonable one. It's not as though this would be something in this day and age that would be too difficult to provide as an adjustment. And you have failed to provide that adjustment, therefore arguably you've done that because of my disability, or on the flip side, or even in the same circumstances, you've imposed this requirement or condition on me, I can't comply with it, and it's not reasonable in all the circumstances that you've done this. The million-dollar question of what is a reasonable adjustment arises frequently with clients I speak with, and even in cases that are run. Another classic lawyer response to you is, it really depends on all of the circumstances of the case. And reasonable, of course, in the law has an objective element. It's not subjective. It's not an adjustment that the person thinks is appropriate or necessary. It's not an adjustment that the school or the employer thinks is appropriate or necessary. It's a reasonable adjustment. It's an objective standard that would ultimately be determined by a court looking at the subjective views of both of those parties, but also all the surrounding objective circumstances of the case. Two other forms of unlawful conduct protected under the DDA that I'll mention very briefly. One is harassment, so harassment on the basis of a person's disability. That features in employment and education only. It really is where there is one or more, there can even be one or more forms of direct or indirect discrimination that have taken place in respect of a student or an employee with disability. You don't see it run very often, but it sits there on the statute books. The last form of unlawful conduct under the DDA and also reflected in the state and territory legislation is victimisation. That too is a very particular form of unlawful conduct. It may not equate to what you and I consider to be victimisation. What must be shown is that, and it normally requires written evidence as opposed to word against word, must be shown that a person has been treated adversely or less favourably because that person has brought a complaint to court or to the Australian Human Rights Commission or to Anti-Discrimination New South Wales, and in doing so, because of that, they've been treated adversely or less favourably. You have to show a link between them bringing a claim or even stating they may bring a claim and the adverse conduct by the employer or education provider. One example might be, I'm an employee, I'm under performance review, I have a disability, I have a meeting. After the meeting, an email comes from my employer that says, we think we'll sack you, Ben, because of your brain injury. I email them back and say, well, that sounds outrageous. I think it's discrimination. And tomorrow I'm going to file a complaint to the Australian Human Rights Commission about you doing that, or if you do that, that's what I will do. And then the next email comes and my employer says, now that you've said that, now that you've taken that defensive approach to file a complaint, we're terminating you today. That would be a classic example of victimisation. Can I say I've never seen such a set of emails between employer and employee. So they're very difficult to prove is what I'm trying to say, but it sits there and is a form of protection for people with disability. Topic 4 is what do the education standards cover and do? They set out in what are called parts, different aspects of education, the education system. They talk about making reasonable adjustments in the education context. Now, of course, that's already covered under the DDA itself. They cover specifically the topics of enrolment, participation, curriculum development, accreditation and delivery, student support services, harassment and victimisation, and lastly, in the slide you'll see Part 10 are exceptions. I'm going to come to exceptions and exemptions in a moment, but there are expressly in those standards some exceptions. Continuing in terms of the duties under the standards on an education provider, they appear to be as follows, and I say appear because there are not many decided cases on the standards, and those that are decided have been, with respect, poorly run, and I think in almost all cases, and I've set out the names, the titles of those cases if you want to read further on them, that in none of those cases has the applicant prevailed and proven a breach of the standards. But it appears from the wording of the standards that there's a duty on an education provider to ensure a student with disability can participate on the same basis as students without disability. So the standards use a different test, if you like, than direct and indirect discrimination under the Act itself, and that is being treated on the same basis as opposed to not being treated less favourably. Sounds like a cute distinction, but a number of lawyers, including myself, consider it to be quite significant. and that inconsistency at some stage may play out in the courts. They must also, that is the education provider, consult about reasonable adjustments. Consult with the student, with the family if it's appropriate. What they must do to constitute consult, though, is a moot point. Do they just have to pay some lip service and have a quick meeting and say, well, we think we're going to make an adjustment of this ramp here, but we can't afford to do a ramp over there. So, Ben, you'll only be able to access the playground this way. You won't be able to access it through this other way with the other students. Or does it mean meaningful consultation where the student and the parents are actively involved, are asked for their views, and the school considers those views and then decides to make adjustments as it sees fit? There's a duty to make reasonable adjustments under the standards. However, it's not all adjustments that a student or their parents or family ask for or request. As I've said, reasonable adjustment is a term of art under the Act and is determined in all of the circumstances. And what is quite clear from the decisions, the judgments so far, is that it is the education provider at the end of the day who gets to decide what adjustments are made, not the family, not the student. They must also take reasonable steps to make those adjustments in a reasonable time. That's obviously important because disabilities change over time, and so it might mean that a student or an employee with a degenerative disability requires other adjustments over time. And the standards recognise that, at least in the position of education, that should be done within a reasonable time. Yet again, of course, though, that the objective word reasonable rears its head. And lastly, there's a duty on the education providers to prevent victimisation and harassment, matters that I've referred to a moment ago in respect of the DDA itself. On my next slide, I've set out some judgments that feature the education standards. All of those involve the education system down in Victoria. They're getting on to 10 years old, at least one of them. Sadly for, I guess, the disability rights cause movement, those matters, those cases were unsuccessful for the applicants. As I said earlier, and with the greatest of respect, I don't think they were run in a robust way and perhaps were misguided in terms of what could be achieved. So, in a nutshell, let's hope perhaps that there will be stronger cases run by applicants and that there will be judges and decisions that come and are made by the courts that provide a little bit more guidance and positive guidance to students with disability around those standards. So watch this space. Topic 5, I flagged a moment ago. Are there defences or exemptions to unlawful discrimination? Short answer is yes, there are. In terms of education, where I'll start first, there are defences under the DDA and also they're reflected in that Part 10 of the education standards as follows. Firstly, and this is really a defence to a direct discrimination claim, an act was not done because of disability. It might be quite clear that there was a decision made, but that what motivated it, what caused it, what the basis or the ground of it was, had nothing to do, or not substantively anything to do with a person's disability or a student's disability. Secondly, there's a defence which the school or the education provider must prove, and I should point out that these defences and exemptions in a court must be proven by the education provider. The second is that the Act was reasonable in all the circumstances of the case. So imposing the requirement or condition was reasonable in all of the circumstances. And really that's a defence to indirect discrimination. The third defence or exemption that is in the standards, in the DDA, and in fact is in all of the state and territory legislation relating to anti-discrimination, is to avoid the discrimination it would have caused an education provider or an employer, because it applies it in employment as well, unjustifiable hardship. Now, yet again, what does unjustifiable hardship mean? I can't give you a definition that you can use as a template to apply to every set of circumstances. It relies entirely on the particular circumstances of each case. It factors things like financial impact on an education provider of making an adjustment, for example. It factors in the effect an adjustment or an act might have on other students in a school, or teachers in the school, or a host of other facts that may be relevant in the particular circumstances. So unjustifiable hardship really incorporates many, many factors. But as I said, it is on the education provider to prove that defence before a court. There's also a defence in the standards called academic integrity, or really I think it's looking at the inherent requirements of a subject or course. That defence or exemption, in a nutshell, says that a course or a subject can only be amended or changed or adjusted for a student with disability to the extent it does not derogate, take away, harm the academic integrity of that course or subject. It's similar, I think, to the topics of reasonableness and unjustifiable hardship, but it is set aside as a specific exemption in the education standards. It really goes to curriculum development, adjustments of courses, perhaps how they're assessed. So a student might say, well, I want this course, the assessment for this course, to be all oral, none written because of my disability. It may be that depending upon the subject and the course, it may be that an education provider would say not all of those adjustments can be made, can't all be oral because of the academic integrity exemption. The last exemption is an act done in strict compliance with another law. For example, complying with work health and safety laws tends to be, as you can tell, more in the employment context where you see something like this. But really it says that, again, the onus is on the education provider to prove that it did an act because it was complying with another act that it had an obligation under. So, for example, it might say, we suspended a child who happened to have a developmental disability, whose behaviour was violent. We suspended them because they had already harmed a teacher. They posed a work health and safety risk to that teacher and other students and other teachers that could not be mitigated by any other adjustment other than a suspension. Therefore, we acted in strict compliance, and strict is an important word here because it suggests that if there is some room to move or some adjustment in terms of complying with another law, an education provider must do that first. But they may say that they did the act, the suspension, in strict compliance with work health and safety laws. Defences or exemptions, turning to the next slide, also, as I've said, apply in employment. I won't walk through those again because really they're precisely the same defences and exemptions that I've described apply to the area of education. Suffice to say, there's a defence or exemption of inherent requirements of the particular job that is particular to employment. And that defence essentially is where an employer says the person who's brought this claim was fired or was treated adversely because they could not meet the inherent requirements of their job. So it might be that inherent requirement of a job, cab driving, is that you can see. We didn't give Ben, who's vision impaired, legally blind, the job because he can't do an inherent requirement of the job. He can't drive safely. That's a very bald example of that defence. It's important, though, that a court understands what the real inherent requirements of particular job are. Also under the DDA, an employer has to consider adjustments to how the job is done, not adjusting or removing inherent requirements. The law doesn't require that, but there might be adjustments that can be made, reasonable adjustments that permit the employee to meet the inherent requirements. And there's an obligation under that heading of failure to provide reasonable adjustment that an employer must consider before they rush off to an inherent requirements defence or exemption. Coming to probably a more practical topic, moving away from the academic scholastic topic of what the law is about. Topic 6 is what can the law achieve and what can't it achieve? It's important to understand that complaints, as they're called under the DDA, are a snapshot in time of one individual and one act or a multitude of acts. In other words, a complaint isn't representative of every person with autism or every person with dyslexia. It's just the complainant, the person, the student, the employee with the disability against the particular employer or education provider at the particular time. That is both pro and a con in terms of applicants bringing cases to court, and I'll come back to that. The flip side of that is representative actions. Most of you would know that regularly we hear in courts people bringing class actions or representative actions for consumer issues or breaches by the government of particular rules. Representative actions were dealt a significant blow by a case I'll just call Access for All, and I've included a reference to it in the slides. Essentially, the courts emphasise that complaints and proceedings are confined to the individual. So what that really means is that the relief or the compensation or the outcome that a court can give if an individual is successful is confined to them. The courts can't come along and say, we're going to ensure that every set of bubblers and toilets all across Queensland councils are accessible to people with physical disabilities. We're not going to do that. It's about one park, one set of toilet facilities and public toilet facilities at a particular park in Harvey Bay on a particular day, brought by one particular person. That's really important to understand in terms of people who, rightly, and I understand why, feel very strong about particular claims or complaints they want to bring, and that they want to make sure that it doesn't happen to others in the future. While admirable and understandable and altruistic, that's not a cut and raw what the law or what the courts can necessarily achieve. But saving grace is, in my view, a judgment in favour of an applicant. While it might only mean some compensation, monetary compensation to the person, it might mean an apology, the declaration that unlawful discrimination took place is a potent and powerful tool for systemic change. In other words, what goes on behind the scenes of an education provider, a government service, an employer, when they have a judgment against them, in my view, brings a systemic change. They don't want another claim like that again. They don't want to get it wrong again. So these are individual complaints where one hopes to, if run to court or tribunal, get a successful outcome, judgment, and that is the ticket for systemic change. What can you achieve by accessing the law and running matters towards the courts or to tribunals? Well, you can gain a catharsis in a conciliated outcome. So in New South Wales, if you bring a complaint, you can choose to go to the Anti-Discrimination New South Wales, or ADNSW, or the Australian Human Rights Commission, a disability discrimination complaint. Once they understand the complaint and they accept it, once they give the education provider or employer a chance to respond to it, both of those organisations do their best to bring the parties to a conciliation meeting, conference, where the parties try to nut it out and resolve it informally without needing to go to a court or a tribunal. I can't emphasise more how important that stage is, and being realistic about what you can achieve, what you can't achieve, and being able, and I know people don't like this word sometimes, able to compromise, because that is what will have to happen usually by both sides. People often say, conciliators and others, is have a mindset of what you can walk away and live with at the end of conciliation, not what you think you should get, not what is the best case scenario, but what you can live with. At that point, you may not have even needed to get a lawyer. You wouldn't have expended much cost. You wouldn't have invested a lot of as much emotional energy, stress as will happen if you go to a court or tribunal. You have control about the outcome. You can ask for a range of different forms of outcome. You might even get some systemic outcomes. You might get training or review of policies by an education provider. You don't get that control or those outcomes necessarily if you take your matter to a court or tribunal. So be mindful of that. It's also a timely result. So it's not one that might drag on for months, even years, and I'll come to how long courts and tribunals can take to provide judgments in these matters. Courts and tribunals as well are conservative. They're reluctant to make outcomes or give judgments or make orders that are groundbreaking, and that's said with the greatest of respect. They tend to be very conservative about how they approach these matters. For instance, they won't make orders that require supervision of an employer or government agency or an education provider to go off and do a whole lot of things like review policies or train people. They just don't do it. They're good at giving compensation, monetary, and what's called for pain and suffering usually. They're good at, and even sometimes reluctant to, order an apology. They're good at obviously making declarations that unlawful discrimination has happened. But doing anything like taking reasonable steps to do other things, which definitely sits in the DDA as a form of relief or outcome, traditionally they've been reluctant to engage in. The other thing, of course, at court or tribunal are legal costs and the stress and resources that go into running these sorts of cases. They cannot be downplayed. Looking at the Fair Work Act, which is topic 7, this is a Commonwealth industrial piece of legislation that's been in now for over 10 years, getting on to 12 years. In it is a section entitled Section 351, and it's another form of recourse for a person with disability only in employment who considers or has evidence or a claim that they've been discriminated against for disability and also a range of other attributes. So the discrimination under Section 351 recognises race, sex, religion, national origin, pregnancy, disability, marital status. So all those things are covered under this section. It falls within a section that's entitled General Protections, or otherwise known as Adverse Action. Put as simply as I can put it, what it protects or what it prohibits is an employer treating an employee less favourably in a workplace, for instance, demoting them, dismissing them, by reason of one of these protected attributes, in the case we're discussing today, disability. The section refers to the DDA and other relevant state and territory statutes regarding anti-discrimination, and essentially says that where discrimination is recognised under those acts, it will be recognised under this act, but also the exemptions and defences like unjustifiable hardship that apply in those acts also apply here. Sometimes a person with a disability will have a discrimination argument in employment, but they'll also have a broader claim under general protections or adverse action. I won't go into that because those types of actions are complex themselves, but what it means is rather than, and you need to make a choice, rather than bringing a disability discrimination claim through the DDA into the Australian Human Rights Commission and off to the federal or federal circuit court if it doesn't conciliate, or bringing it through Anti-Discrimination New South Wales and off to the tribunal here if it doesn't conciliate. Here an employee can bring their discrimination claim through Fair Work under this Act, and they can also bring with them other claims. For instance, they might bring a breach of their employment contract claim, and they might bring claims of other forms of adverse action. So an avenue worth noting for you, and if you're talking to a lawyer and it's an employment discrimination case, to discuss with them whether that's an avenue available to you. The next couple of slides in topic 8 are my practical tips on making a complaint and indeed warding one off. So not even getting to the stage where you've got to go to the Australian Human Rights Commission or the Anti-Discrimination New South Wales. These are practical tips. And again, forgive me if a number of them are quite bleedingly obvious to you. Be surprised though how often, and this speaks for both an applicant and a respondent. When I say respondent, an education provider or an employer, it amazes me when I look at what's been done or not been done, how some of these steps could have been taken early on, and perhaps the claim would never have come to the court or tribunal where I'm suddenly being called and being involved, and lots of money and stress is being expended. Firstly, do your best to informally resolve the issue early with your school or employer. Sometimes, and regularly in education, personalities and egos get in the way. People get burnt out. Parents and principals are at loggerheads. In those situations, is there an independent person that both sides trust, both feel they can speak with? That might be a way to bridge the gap and to informally resolve the problem or the issue. Keep a diary or record, and it can be written or audio, as long as it's a contemporaneous record of the issue and all the interactions you have with the employer or the education provider. I should say I'm coming in my practical tips here from the perspective of a student or an employee, not the other way around. Having said that, I do work, I should have said this at the outset, both for applicants, for students, their families and employees, but I also do work for employers and education providers in the discrimination context. So I'm looking at it, I'm giving you this advice from the perspective of someone who might want to bring a claim, but with the benefit of seeing it from the other side. Keep copies of all things that are sent to you and you send off, so emails, letters. Do it as early as you can, even if you think it's not going to become serious or blow up or that it will be resolved. Do your best to keep those. You'll be lauded by your lawyer and barrister down the track if you've kept all of those things, and they may prove crucial to a claim, or crucial as a document to put under the nose of an employer or education provider in a conciliation where everything is confidential, can't be used further down the track in court, but it might be a really critical document to put in front of their lawyers to persuade them that they should settle the matter at the conciliation. Think about, is there a policy or a handbook, employee handbook, for example, that applies in these circumstances? What does it say? Can you talk to your employer or education provider about that policy? These two are important documents at conciliation, and very much so if a matter goes to court or tribunal. Be very clear about how you want the issue resolved. I'll say be realistic about that as well, because you need to be. And I say that as respectfully as I can, because I'm an impartial, emotive barrister in these matters, but I also understand the passion, the frustration, the strain that parents and students, in the case of education, and employees who may have been long-standing loyal employees, feel about how they've been treated and what they feel they want or should get as a result of bringing a claim. But be very clear about that. What outcome do you seek, and how will it play out if that outcome is agreed to? Next slide, still looking at these practical tips. If you can't resolve it informally, that's when I think, if you can, speak to a lawyer or community legal centre that can give you some free advice at least. Be careful about lawyers and discrimination. It's a really nuanced and niche area, I think, and there aren't a lot, even from my experience, a lot of solicitors in the community that know it or do it well. So I say that, give that advice cautiously, and perhaps a community legal centre that won't charge you with some expertise in discrimination is the best port of call. But of course their resources are very limited. You can also access, look at, read, audio read resources that are on the Anti-Discrimination New South Wales website. They're very helpful, and also the Australian Human Rights Commission website. If you take your complaint the Anti-Discrimination New South Wales way, I've covered this to some degree. They'll seek to understand the complaint, they'll give the respondent an opportunity to respond in writing, and then they'll invite the parties to conciliate. That also applies to going down the Australian Human Rights Commission path. Same format. If going each way the parties can't resolve it, then going the Anti-Discrimination New South Wales way, a person can bring their claim, take their claim further to the New South Wales Civil and Administrative Tribunal, NCAT, and in the case of the Australian Human Rights Commission complaint, a person can file in the federal jurisdiction, the federal court, or Federal Circuit and Family Court of Australia, as it's now called. Do I need a lawyer? So when? Well, you definitely need one before you take your matter to the tribunal or to the court, in my views, particularly the court, because the court is a cost jurisdiction. So if you lose, ultimately, or you try to pull out halfway through and you don't want to proceed with the matter, you want to discontinue, an education provider on the other side or an employer can ask the court for you to pay its costs thrown away and wasted. So it's really important at that point to get some good legal advice. Lastly, on that slide, be realistic about what a case can achieve, and I've talked to you about that. What will its costs be? Not just money, stress, strain, not knowing whether you're going to win, lose, not knowing whether you're going to have costs against you from the other side in the end. Really important things to think about. Conciliation, you'll see in capitals, in my view, is an excellent stage to conclude things, and most matters resolve. I think it's something like 90% or up in the 80% zones for both the Anti-Discrimination New South Wales Forum and the Australian Human Rights Commission Forum. But if you go to court or a tribunal and you can't conciliate, how long could it take? It can take many months, it can take into years. And if you look at some of those education cases, the Walker case that is set out, I've provided references to against the state of Victoria, in them you can see the timeline. You can even see the timeline of the days the matter has had to be in court. They can really stretch out. What will it take if it goes to final hearing? Well, the student or the employee with disability likely will have to get in a witness box and be cross-examined. You'll probably have to get experts about the disability or adjustments. That will cost money, take time. Might be hard to find an expert to give that evidence. They might be reluctant to go to court. You will need to probably engage with lawyers. You'll need to prepare documents, submissions, statements, affidavits. There's a lot that goes into getting a matter to final hearing. Just to note, once a person gets into the court or the tribunal, there is a second conciliation type stage, and it's called mediation. So you get a second bite of the cherry to informally resolve it. I would stress at that point, it's a critical point to really consider whether you can and want to informally resolve it. My last topic, I've set out topic 9, judgments and possible scenarios. On the first slide, I've set out significant disability discrimination judgments. I won't traverse those, noting the time I've already expended today, but they are there for reference if you want to look further into the law and understand what the law can and can't achieve in disability discrimination. The cases, I think all of these education cases, are prior to the 2009 amendments that brought in the failure to make reasonable adjustments, so bear that in note. Some of them are very early on, but they are still authorities and judgments that are referred to by the courts. Similarly, the next page under the topic heading of employment, I've set out there some of the more recent, and again, time's getting away. We're now 2021, almost 2022. Some of the cases that are important from the perspective of employment disability discrimination. In the case of Watts and Huntley that you see referred to there, both of the applicants there were successful. So they're useful guidelines or points of guidance about how to run a case well, and they both featured an argument of their employer failing to make reasonable adjustments, and the court found in their favour. Turning to, I think it's the third last or fourth last slide, and this is the start of the possible scenarios. What would you do? I've provided, I think, 6 scenarios. I might just discuss 1 or 2 and make some suggestions around what you might do. Some of those suggestions might already be apparent to you from what I've talked about so far. And I've got to say, some of these, in fact, maybe all of these, are based on scenarios that have come to me or that I've observed or I've even appeared in. So you might sadly be staggered at some of the things that have happened to students. In particular, these are mainly students with disability. I'll look at B. Here, a student with cerebral palsy comes to you and says his drama teacher made a joke in a drama class about breaking a leg on stage, and then pointed to him and said he needed to be particularly careful, then laughed. This is based on something slightly changed that came across my desk about 15 years ago. On the face of it, it seems like this is direct discrimination, that this student has been singled out, treated less favourably because they have a disability, that being cerebral palsy that manifests in a physical impairment, I suppose, and that they've been picked out in the classroom by a teacher who is the employee of their education provider, and they've been treated less favourably than other students in that class. It would seem, again on the bare bones, and we don't know all of the circumstances, and of course all of the circumstances are very important to understand, that on the face of it this would be an example of direct disability discrimination. I would suggest that the family, with a lawyer or advocate, speak with the school, note it, see whether the school responds appropriately, accepts what's happened, what the response of the teacher is, whether they're subjected to disciplinary action, whether they provide an apology, those sorts of things. And if that doesn't happen, then consider whether a formal complaint to the Anti-Discrimination New South Wales or Australian Human Rights Commission would achieve what outcome is sought. Turning to page D, you're on an interview panel for a new role at your work. One of the other panellists says that he would like to recommend applicant A, but he's worried about that applicant's disclosure that he has depression, and the panellist thinks that that would likely be a real liability in the position. The panellists instead recommend applicant B for the job, and applicant B gets that job. This example shows the difficulties in proving, and in an applicant proving, that they've been treated less favourably because of their disability. This is an interview panel discussion behind the scenes. It's not in front of the prospective applicant or the prospective employee. It doesn't appear to have been sent in an email or a document that can be later subpoenaed or disclosed or proven or produced. These sorts of matters, unless one of those panellists comes forward and says this is what happened and I'm willing to put my hand up and say I think this is outrageous and discrimination, proving that this is direct discrimination or indeed indirect perhaps would be very difficult. But on its face, it's absolutely direct discrimination and classic application of stereotypes to a label in a person's disability. There are 2 more scenarios. I won't go through those. I'll leave those for you to read and consider. Again, they are topics and scenarios that have come before me in various forms over the years. Noting the time, I'd like to leave it there. I'd like to thank you all for having me along to this virtual conference to provide some insight to the work that I do. It's an area I'm very passionate about. On my last slide, I've set out my email and my phone details here in Sydney. If you want to ask me any questions or anything of that sort, please feel free to do so. I'd only be too happy to do that. Thank you again. I wish you and Judith and all the foundation and the team the very best for this virtual conference. Thank you.